When we saw something with our eyes, when we smell something with my nose, when I taste something with my tongue, when I touch something with my skin, when I heard something with my ear. This is a perception. A very classical definition is that perceived by my sense. Another important point is any mental condition of which a person is conscious. So simply because of the fact that you perceived by your sense alone is not sufficient. Another important point is at that time your mental condition must be conscious. Only when your mental condition is conscious, then only it can be considered as a fact. This is the reason why the court is very much doubtful at the time of admitting evidence of an infant. We are aware of VIJI-S test under Evidence Act. VIJI-S test means whether that person is mature enough to give evidence before the court. We know that simply because of the fact nothing is an offense done by a child below 7 years, but a child below 7 years can give evidence before the court. So how he perceived that thing, whether his mind is mature enough to give evidence, simply because of the fact that he saw it, how he perceived it with his sense is a crucial question. This is the reason why when an idiot, a lunatic, an old man or a child is permitted to give evidence, provided the court must satisfy that he is capable of giving evidence. How can we say that a person is capable of giving evidence is a matter of satisfaction for the judicial officer? Perception varies. Your sense varies. And sometimes you may have some perception under a delusion. There are so many stories that so many people saw God and they become the messengers of God. So whether such a concept can be admitted as evidence? Perception must be from your sense, and you must perceive that sense from a mental condition in which you are conscious. So if Gautama Buddha comes before the court and say that I am enlightened, it is very difficult to say that whether such an evidence is admissible under law of evidence. It is not a fact under the law of evidence, because under law of evidence, the question of consciousness is very important. You may be under an enlightenment stage of unconsciousness. Consciousness in the sense, consciousness of a reasonable and prudent man, which the court shall expect to believe. The court must believe that yes, his sense is correct. So it's a very scientific, precise definition. So anything, state of thing, relation of thing, capable of being perceived by any one of your five senses, plus your mental states, which is of conscious mind, constitute a fact. You are expected to give evidence only with respect to those aspects before the court. Of course, court permit you to give an oath in the name of God, but you can say that I saw God. Your belief is different, and your perception admitted by the court or believable by the court is different. Any confusion regarding that area? Okay. Now, we can consider the most important aspects, that is fact in issue. I'm not dealing with the relevant the definition of relevant for the time being, but it will come later. Fact in issue. There may be hundreds of facts, and the court is not very much interested to decide each and every fact. If court is going to ponder the correctness of each and every fact narrated by the party, the trial will never come to an end. Court is conscious and court is interested only in deciding the fact in issue and fact in issue only. And what is this fact in issue? The expression fact in issue means and includes. Instead of going into the literal definition, I'm just reading the literal definition, but we can expand it in the practical sense, because Evidence Act is more or less a practically oriented art. The expression fact in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability, disability, asserted or denied in any suit. So the word suit for the first time specifically comes into play in Evidence Act. In any suit or proceedings necessarily follow. Here we can see that there are so many facts, especially in a civil litigation. There may be a chain of facts, and the court is interested to decide only the fact in issue. For example, take the case of just you go through a plate where you can see that hundreds of facts may be there. The court is very much constrained to cut down the case into specific issues. And court is permitted to give you evidence only based on issues. For example, in a suit, A pleaded that A and B are friends for a long period of time. In the second paragraph, he says that A requested so many times to B to give an amount of rupees 5 lakhs. In the third paragraph, again, he says that initially A refused to give that evidence. Initially A refused to finance B. In the fourth paragraph, he says that B again came to my house, repeatedly requested me to give some amount. Finally, I decided to give him 2 lakhs rupees. In the fifth paragraph, he says that on such and such a day, he came and I gave him 2 lakhs rupees. In the next paragraph, he says that despite repeated demand, he is not ready to pay that amount. In another paragraph, he says that finally I went into his house and he executed a promissory note in my favor. And in the next paragraph, he says that despite repeated request, he is not ready to pay the amount. In the next paragraph, he says that I sent an advocate notice and the B is not ready to pay that amount. And finally, you are praying that you want that money. I'm just summarizing a suit because of positive time, whatever it is. Here, the court is not going to consider the question whether A and B are friends. The court is not very much interested to know whether A came to the house initially and request an amount of rupees 5 lakhs. The court is not very much interested to decide the question whether actually B again came to the house and finally A decided and all those things. The crucial question the court wants to know is first, whether A give an amount of rupees 2 lakhs to B on a particular day. Second question, whether B executed a promissory note in favor of A on a particular date. These are the real issues to be decided. Apart from the legal issue, there may be legal issue, and legal issue need not require evidence in the strict sense. There may be legal issues may be a mixed question of law and facts. For example, res judicata, we know, is a mixed question of law and fact. Limitation, to a certain extent, it is a mixed question of law and fact, not purely legal question. But the opposite issue I have narrated, whether he borrowed an amount of rupees 2 lakhs or not, whether B executed a promissory note in favor of A on a particular day or not, is necessary for the fair disposal of the suit. These are what we call the fact in issue. So fact in issue, put in other words, is just like the brain and heart of our body. Without this brain and heart, we have no existence. So these are the issues that the court is expected to decide. Evidence is permissible with respect to the fact in issue, and fact in issue only. This is the first part. Don't be under the mistaken impression that evidence is not permitted on any other score, but evidence is available evidence is permitted to be adduced on fact and fact in issue, not on every fact. So here we can see a systematic difference is laid between what is a fact and what is a fact in issue. What is the purpose of this differentiation? First, when adducing evidence, the court is evaluating whether the evidence given by the party is a fact or not. If it is not a fact, does not support that it is not anything, state of thing, relation of thing, capable of being perceived by you, or a mental condition of which you are not conscious, the court straight away refused to record that finding, saying that no, this question, your evidence itself is prima facie prohibited under Evidence Act. It is not at all a fact. Again, the evidence you give may be a fact, or it is a fact, but that fact is neither relevant nor a fact in issue. A judge is supposed not to write question permitted under Evidence Act. So this is the reason why, when I think that most of the students watching this video are Munsiff aspirants. A Munsiff is always expected to frame issues. Do you know how to frame issues? Framing of issue means when plaintiff filed the suit and thereafter defendant filed his written statement, you are expected to cut down the case, crypt and cabinet the case into specific issues. Issues, as we know, is divided into two: issue based on law and issue based on mixed question of law and facts. So when mixed question of law and facts are there, those issues shall be specifically laid down by the judges, and you are permitted the party to ask question based on that fact in issue and relevant facts, and not on any other aspects. Otherwise, there will be no end for a trial. Trial will never come to an end, and you are totally deviating from the actual issues to be decided. This is one of the reasons why we are saying that the 1872 age-old Evidence Act is very systematized in deciding the crucial issue or fact in issue. Now, I am going to invite your attention to the most interesting aspects. I think that my time limit is, may I just continue one more section, or we have to?
Yes, sir. It is very interesting, so you can continue. Yeah.
I proceed a little bit without
Yes, definitely.
Now I am considering the next interesting section that we know is res gestae. Res gestae under section 7, under 6 of the Evidence Act says that facts, though not in issue, facts, though not in issue, so connected with the fact in issue, so as to form part of the same transaction, is relevant. Facts, though not an issue, I'm taking the first part, it's a fact, so it is permissible. But though not an issue, this is not a fact in issue, but so connected, not connected, so connected with the fact in issue. So facts, though not an issue, so connected with the fact in issue, so as to form part of the same transaction, is relevant. It is immaterial whether that incident happens at different places or different time, or at the same place or at same time. This is what we called the age-old principle of res gestae. Res gestae, we know, is a Latin term. Res gestae simply means things done. And res gestae is an exemption to hearsay evidence. When we are discussing evidence, we know that no evidence is permissible unless you directly feel it by either of your 5 senses and with a conscious mind. But in this particular incident, You have not seen the exact incident, but you see something which is so connected with the fact in issue. It is not the fact in issue, but it is so connected with the fact in issue. I'm just remembering, just recollecting an old story told by my own mother when I was 2 years. At that time, you know that some people love mongoose, and one mother loved a mango very much, and a baby is always scared by that mongoose. One day she go outside for some purpose, and when she came back, she found that blood is in the mouth of the mango. She's very much infuriated under the mistaken impression that the mongoose bite the child, and she killed that mongoose. Subsequently, she found that a snake was attempted to attack the child, bite the child, and the mongoose actually killed that snake, and the blood from the mouth of the mongoose is not that of the child, but of the snake. So, why I am telling this interesting aspect is, it is not necessarily correct that the things so connected with the fact, things so connected with an incident may not reveal the actual facts. Maybe or may not be. But when things so connected with a fact in issue, can you always say, really strengthen or support the fact in issue? When we are discussing this complex question, because hearsay, res gestae is an exemption to hearsay evidence. The court is very cautiously accepting evidence with caution that in order to decide a fact in issue, there is no evidence. But you witness something which is closely connected with the fact in issue. You did not say that he executed the promissory note, but you just say that he came, you just say that he opened the nib of the pen and is going to write the promissory note. By that time, I passed through that area. Thereafter, this document is before the court, and the signature of A looks like that of the original signature of A. A is now no more. You are giving an evidence that I saw an act nearing to the execution of the document, but I did not see whether actually he executed the promissory note or not. Similarly, I saw a person running out of the house with a blood-stained knife. Subsequently, people saw that a person was murdered inside that house. So only this particular part of evidence is admissible. When we are evaluating, in almost all probability, the person who came out of the house with the blood-stained knife might have committed the might have committed the murder. This is not a circumstantial evidence. Circumstantial evidence is entirely different. This is an evidence you saw, and it is nearing to or so connected with the fact in issue whether A murdered B or not.
Different news reported in Hindu, which I consider it has a constitutional importance. And the second issue reported by this Hindu, which is I think is a constitutional